Good afternoon, Mr. Miller.
Good afternoon, Chief Justice, members of the Commission.
How are you, sir?
I'm well, and you?
Very well, thank you. Um, you you've been an attorney for how long?
For 24 years.
24 years.
Correct.
And tell us about your exposure to judicial responsibilities and how that has prepared you for this interview.
Thank you, Chief Justice. I've acted in the Gauteng High Courts, both Johannesburg and Pretoria, for a period of 42 weeks.
42.
42 weeks over the period 2017 to the present. And during that time, I've had exposure to I would say, a substantial amount of different judicial work, and I've had the opportunity to adjudicate matters and deal with various matters. So I do feel that those number of weeks and the scope of the work to which I've been exposed has prepared me for judicial office.
Did you do both criminal and civil work or only one line? And if so, what is it that you were confined to during your acting stint?
Chief Justice, I've sat in all courts save the criminal trial court, although I have spent, I think, 9 weeks doing criminal appeals. In those weeks, one deals with anywhere between 2 and 6 appeals. So I have had, I believe, significant exposure to criminal work, although at the appeal stage. In regard to civil matters, I've dealt with the entire gamut of civil matters, both unopposed motions, opposed motions, trial work, and special motions as well.
As an attorney, did you also appear in court?
Yes, Chief Justice, I have on occasion, although given the nature of an attorney's practice, it's not quite as frequently as one would if one was at the bar, but I have appeared.
That's why I'm asking. What about in the High Court?
Yes, I have appeared in the High Court.
For that period over which you've been an attorney, how many times would you say, more or less, you had occasion to appear in the High Court?
Chief Justice, I would say perhaps 20 or 30 times over the period.
Or over the 20-odd years of practice?
Yes, over the 24 years.
Now, judgment writing, on average, how long did it take you to deliver a judgment?
Chief Justice, I try when it's at all possible to deliver a judgment within the week that the matter is heard. My average is 1 to 2 weeks. There have been rare matters that have taken up to a month because the exigencies of the case required a bit more consideration, but nothing more than a month.
Nothing more than a month or 3 months?
Nothing more than a month. Let me qualify that and say that I was a member of a full court in February of this year that dealt with matters relating to the Legal Practice Act, and the reasons that were handed down weren't handed down within the 3 months, but the orders were given timelessly by the full court. So that's the only case where the furnishing of the reasons didn't coincide with the delivery of the judgment. But there were specific circumstances that necessitated that is how things were done.
Yes. JP?
Thank you very much, CJ. Anthony, good afternoon.
Good afternoon, Judge Millar.
You've done 42 weeks, although my spreadsheet says 41, but I'll accept 42 weeks.
Yes, sir. Your spreadsheet I gave you in September, but I sat in the urgent court last week.
Yeah.
So that's why I have an extra week that you don't have on your spreadsheet.
Now, you've done 6 weeks in the opposed motions. Is that a difficult court?
In some ways it's difficult, in others not quite, because with an opposed motion, you're given the entire file with all the papers The issues are crystallized on the papers. You have the benefit of heads of argument from counsel. So it's a lot of work, but it's really prepared for you, and you're able to engage and deal with the work straight away. So I would say it is a difficult court because the issues can be complex and there can be a lot of paperwork that one has to navigate through, but it's not an impossible task, and I've found myself equal to the task on each occasion when I've sat in those courts.
Yeah. Now, you say the average delivery time of your judgments is a week to 2, even in that court?
Yes, even in that court.
I wonder why, because the opposed motion court has matters that require some time of reflection, and so can you share with us how is it possible that you are able to turn around
Yes.
within a week or 2 in opposed motions?
Yes.
When much more experienced judges take longer.
Yes. JP, because I act, I don't have or always have the situation where the week before I sit in the opposed motion court, I will have other work that will spill through and require an ongoing work. So I've had the privilege on most of the occasions of having the files beforehand and having had an opportunity to read all the files and prepare before the commencement of the week. So I would think that is probably why, in my particular case, I've been able to deal with it in that way. But I recognize that if one has a spillover situation where you're sitting for long periods of time and there's commitments from prior weeks that would also need to be addressed, it may not always be possible to deliver judgments within that time period. So that is my time periods, given the context within which I'm sitting at the moment. But it may be that slightly longer would be needed, in other circumstances.
Yeah. And I see you've done 9 weeks of appeals.
Yes.
That was the same situation. You've sat in full courts?
Yes, Chief
where
Justice.
you scribed the judgment?
Yes, Chief Justice. I've sat on 3 occasions. I've written for full courts.
And it still took you that 1 week to 2 weeks?
Well, the full court period judgments took slightly longer because one has to send the draft to colleagues for their consideration and to address concerns they may have. So those full court judgments weren't delivered quite as quickly as matters where I sat on my own, but they were still delivered well within the time periods set out in the norms and standards.
I mean, you've also done 4 special civil trials. Those are complex civil trials. Was your turnaround the same in judgment time?
Chief Justice, I was...
sorry, the Chief
sorry.
Justice is there.
Apologies.
No, you know how it works. He's addressing the one presiding.
Thank you, Chief Justice. Judge President, I was allocated to the special trials, and what happened in those weeks was, on the one occasion, for whatever reason, the parties decided to postpone. So in a 2-week period, the parties postponed, and I landed up assisting with the ordinary civil trial role. So there was no special trial that specifically ran. And on the other occasion, I was allocated to the full court in the Goosen matter, and so there was a realignment, and I landed up sitting in criminal appeals and doing other duties, so that my presence on the
My last question, CJ. Do you have criminal trial experience?
Chief
Either as
yes.
a law practitioner, I know you've not
Yes.
acted in that court.
Yes. Judge President, at the start of my career, I did have some exposure to criminal trials,
Yes.
but not for many years.
Okay. Thank you very much.
Thank
For the record, you've penned something like 15 criminal law judgments.
Yes, thank you, Judge President.
Thank you, CJ.
Thank you, JP. MEC?
Very much and good afternoon.
Good afternoon.
Can I just ask you just to share with with us just what has been your success on promoting transformation, and how do you seek to promote it moving forward?
Yes. MEC, I'm a firm believer in leading by example. So everything that I do, whether it's in my practice, whether I'm in an official capacity within the profession, or even on the bench, I would lead by example. Thus far, within the context of practice, we've taken the opportunity to train candidates from who might not otherwise have had access to those opportunities for training, candidates from what are referred to as previously disadvantaged backgrounds, to do articles with us. And in fact, of the recent crop of candidates, we have 4 professional assistants, 3 of whom are ladies, and of the 4, 1 is a black man and 2 are black ladies. So within the context of what we can control in our practice, we lead by example, and we transfer skills, and we empower those who work with us to enter the profession and do better. Within my role with the organized profession, whether at the Law Society or even now at the Legal Practice Council, I've followed through on that approach, and when initiatives have been necessary and steps have been necessary to ensure that we ensure that knowledge and skill and access to the profession are shared amongst everyone, that steps are taken to ensure that things are in place to do that. So to point to specific individuals is not always possible, because it's not happening on an individual basis, but it's happening within the practice on an individual basis. But within the organized profession, it's really been on a macro basis, where the things that I've been part of and that I've been able to assist in promoting have hopefully filtered down and will broaden access across the board. In the judicial context, I think I would carry on this in the same vein, and it's would then really be case specific as to the opportunities that would be available to do that. So when one's in one's own practice, one is really a free agent to a certain extent to initiate and to do things. If one is working within an organization and part of an organization, then one works within the structures within that organization to bring about the goals and the ideals that the organization is moving towards.
Commissioner Kane.
Thank you, Chief Justice. Good afternoon, Mr. Millar.
Good afternoon, Ms. Kane.
In the course of your service on the Legal Practice Council, you've had recently to deal with questions of leave to appeal and the standing of the societies of advocates post the Legal Practice Act.
Yes.
Do you dispute, or do you agree that that's an important issue of law and of the administration of justice, and that it is an issue of public importance?
Ms. Kane, the Legal Practice Council, no one individual who sits on that council makes a decision in regard to these matters. The council debates these matters thoroughly. Differing viewpoints are placed before the council, and at the end of the debate, there would be either a vote or consensus as to the position going forward. In regard to the Bar Council, the standing of the Bar Council specifically, I think the Legal Practice Act is quite clear in regard to the position as far as the law goes. The Legal Practice Act is now the custos morum of the legal profession. The Bar Councils are important because they represent the interests of members of the legal profession, being the advocates part of the legal profession. But those organizations had the opportunity to amalgamate and to form part of the Legal Practice Council and to put their assets into the pot and to become one with the prior law societies. They chose not to do that. They chose to keep a separate and distinct identity. And I think that is really where what your question is addressing, is whether there is a place for them to retain that separate and distinct identity that they have, as against the jurisdiction of the Legal Practice Council. We're only 1 year into this dispensation. I think it's very early days. There are a lot of very important issues that need to be traversed, and so I recognize the issues are important. There's differing viewpoints, but I trust that the Legal Practice Council will come to a situation that will unify the profession rather than divide it, and will bring everyone together. But that's really a matter for the engagement between the bodies.
My second question pertains to what you would do if you were sitting as a judge in relation to whether to grant leave to appeal when such issues arose. What would be the test that you would apply?
Well, the test is, once a judgment's been granted, whether another court would come to a different conclusion. But that's in the ordinary civil context. These matters involving the Legal Practice Council and the profession generally may also raise constitutional issues which would also or may also need to be considered. So one would have to look at the particular facts of the case. When one deals with this act, this Legal Practice Act, one's dealing with really a number of different rights that one has to take into account. One needs to balance the right of access to the profession, one of the goals of the Act, to ensure that as many different practitioners are given access and the profession can grow and diversify, something which really hasn't happened quite as quickly as one would have liked. But also with that, one has the rights of the public. And the right of access to court has within it also other rights, the right to having a representative who will be able to represent you competently, and things of that nature. So without knowing the specific facts upon which the application for leave to appeal would be brought and the specific rights that would now have to be considered that may not have been considered and dealt with, it's not a question that I'm in a position to answer. I can't say as a matter of principle I would answer one way or another. I would want to know what the issues were first and whether or not legally an appeal was warranted.
Thank you, Chief Justice.
Thank you, SC. Chair Moganisha.
Thank you very much, Chief Justice. Good afternoon, Mr. Millar.
Good afternoon.
In your long career as an attorney, how many black advocates and black women in particular did you brief? And in what type of cases?
Commissioner, we've never kept statistics on it because it's not the sort of thing that we've ever... Personally, I've never kept those statistics because it's a question of doing and not a question of making a list that can one day be presented to justify what you've done or what you haven't done. The firm briefs counsel of all races. We do brief black women. The cases that the firm deals with really determine what work those advocates do. So they're not briefed specifically because it's a particular kind of case. It's just a question of the amount of litigation that would come to court and who would be available to do that litigation. So we don't brief based on anything other than the fact of what work is available and that we trust the person is able to discharge the brief given to them.
Commissioner Norman.
Thank you, Chief Justice. Maybe just to follow up on that very question, if you don't keep any sort of record, how do you then know whether your firm is progressing insofar as transformation is concerned? Because if briefs are just issued randomly, you don't know which blacks you're briefing. How do you, at the end of the year, when you have a look at what you've done as a law firm, how do you then say, I think we've done well, I think we're progressing, or we are regressing? How do you know?
Yes. Commissioner Norman, our firm is a relatively modest-sized firm. We don't have huge amounts of litigation. So we know what matters we have. Generally speaking, I'm involved in those matters. And as I say, it's a case-by-case situation. to be honest, I never contemplated that I would ever have to produce such a list. If I'd ever contemplated that, that I have to do such a list, I would have kept the list. But as I said, we've always, and myself in particular, always worked on a leading by example situation. So I can't express it in any other way. Safe to say that I'm quite comfortable, and my colleagues who work with me know the approach we have, and that we make opportunities available to everybody.
Sorry, Mr. Millar, if you were to ask me now how many black women and black men I've worked with, I can mention them. I may not give you the sum total, but I can mention a lot of them. And I don't see you doing that.
Well, I don't know that it's appropriate to name
Why
people.
not? No, it's no secret. We want to know because we want to know who gets briefed, so that when we have meetings and people complain
Yes.
that these firms do not brief us, we must be able to say, but you are wrong, because we know that this particular firm does brief you.
Well, we work, for example, there's a colleague who we briefed is Helen Ngomane, counsel. Worked with her for a while, and at one stage then we stopped working together because she didn't want to do our work. She'd been offered more lucrative work, and she then started doing that work. We've worked with Nokulungu Makopo, as counsel at the Johannesburg Bar, who does work in the field that we work. We've worked with Nasima Adam, advocate Nasima Adam, also an advocate at the Johannesburg Bar, who does this the particular type of work that the firm is doing.
Yes.
So there are colleagues that we've worked with.
Thank you. And then just to correct something, I think in paragraph 6.2.4 of the form itself,
Yes.
you under labor law you've got none, but then on the following page you've listed labor law. So can you just give the commission the percentage of labor law work that you do? Sorry,
Sorry.
it's on your application form, page
Yes.
13.
Book.
It will be book 3 of 4. You see, under 6.2.4, you've got none.
Yes.
But if you turn over the page, you've actually listed labor law there. You might have made a mistake.
Yes, I apologize. The firm does do some labor law matters, but we don't litigate in the labor court. So I think
Is that why you didn't put in a percentage?
that's why I didn't put a percentage.
Okay.
If you look at the firm's letterhead, you'll see that my colleague Bruce Shipalana holds an advanced diploma in labor law, and he is the one who primarily does deal with labor law matters, but they haven't accounted for litigation.
All right. Okay. Thank you. Thank you, Chief Justice.
Thank you so much, JSC. Honorable Singh.
Thank you very much, Chief Justice. Just one question. Good afternoon, Mr.
Good
Millar.
afternoon, Mr. Singh.
Firstly, I note that you've been a member of the Black Lawyers Association from 1999 to 2015,
Yes.
and that they support your nomination and appointment. Just want to know what's happened after 2015. And then as a follow-up to MEC's question, we in the JSC have a mandate to ensure that we contribute to transforming the judiciary. Now, given the fact that we have this imperative, and all things being equal, if we had to appoint somebody and we find that a female or a black male and the same as you, performed as well as you, and that we have to appoint them rather than you, what would your view be?
Okay. Thank you, Commissioner. I think let me deal with your first question. The legal profession underwent a change in 2015. There hadn't been an election for the Council of the Law Society, a proper election, for more than 20 years. I, as a member, called for the election, and there was a special meeting convened, which was attended by about 450 members of the profession to debate resolutions relating to the holding of an election. The night before the meeting, I was phoned by the president of the BLA at that time, Mr. Busani Mabunda, and informed that he had been given information that an attempt would be made to derail the special meeting and the resolution to hold the election by certain individuals. And one of the things that they were going to raise was that because I was a member of the BLA, I was really coming to call for the election in some sort of Trojan horse or other capacity. And it was felt that the issue of the election was more important than my retaining my membership of the BLA, and that it was in the interest of the profession that I resign my membership so that that election or that meeting could proceed. So I agreed with the President, and he will have the letter on record where it was recorded that that was the specific reason for my resignation. So when the following day, during the meeting and the debate on the resolutions from the floor, this very issue was raised and it was put to me, you're nothing more than some sort of proxy or agent for the BLA, I was able to answer quite correctly and truthfully that as I stood there, I was not a member of the BLA. And on that basis, the vote was carried by about 350 or 360 votes to 40 to hold an election. Once that vote had been carried and the election was now going to proceed, after the meeting, colleagues then said to me, well, if you're no longer a member of the BLA, why don't you stand for election? Because you've taken this step and you've been at the front of this, really bringing this change, why don't you stand for election? And because of the way the profession had been structured previously with the Law Society, the council consisted of 24 people, 12 were statutory, which is where the election needed to take place, and 12 were 6 BLA members, 6 NADEL members who were appointed by those organizations. So historically, I had representation on the Council of the Law Society through my appointed BLA representatives, being a member of the BLA. But once I was no longer a member of the BLA, I was able to stand for election for the other component, and which I then duly did. And until the Legal Practice Act came in on the 31st of October last year, my presence on the council and in the various structures was all dependent upon the fact that I wasn't a member of the BLA. So that is why there's this hiatus of membership. The membership wasn't resigned for any other reason than the fact that when the opportunity arose to be part of change, I was prepared to do it and stepped forward to do it. So that is the reason why my membership's only up to 2015. Colleagues within the organization and in the profession generally know me and know where I stand on matters. I think completing the form again after 20 odd years and filling it in would really have served no purpose. And so that's the reason for that. To your second question, Commissioner, I've been privileged to have been shortlisted and to appear before this commission. Your question is really the issue that this commission must grapple with. I have my own interest, and I sit here in my personal capacity. The commission will decide what is best, and I will accept that the commission, having applied its mind and having properly considered all the candidates, will make a decision which is in the best interest of the country, because this is a matter which really goes to the best interest of the country and not only or necessarily to the interests of individuals. So I'm in the hands of the commission, as I think we all are, and we trust the good judgment of the commission in that regard.
Thank you, Chief Justice.
Thank you, Honorable Singh. Honorable Nyambi.
Well represented, CJ. Thank you.
Thank you so much. Commissioner Sigogo.
I'm also represented. Thank you, CJ.
Thank you so much. Mbovu SC.
Thank you. Good afternoon.
Afternoon, Commissioner.
Is your firm exclusively RAF work, or do you do other types of work?
The firm has a focus of RAF work, but we do other work, but the main focus is the road accident fund work.
Yes. And you personally, do you have experience in other areas of law other than RAF?
Yes, Commissioner, over the last 24 years, I've done a lot of other work to a greater or lesser extent, but the primary litigation was the Road Accident Fund work. We're also notaries and conveyancers and deal with matters related there too as well, property
Yeah.
matters and so on.
Okay, so can I take it, rough estimate, in a year you do how many, 1,000 RAF matters, 500?
No, Commissioner, I think perhaps you've been, you're thinking of the numbers that certain other firms. Our firm, in a year we may deal with at most 50 trials, 40 to 50 trials. We don't do hundreds of cases because one cannot give proper representation to one's clients dealing with it on what can be called an industrial scale. So we've never practiced in that way. We form a close relationship with our clients and we represent those clients to the best of our ability.
No, that's fine. Let's say 50 trials. Of those 50 trials, in how many per year would you say you brief black and women counsel?
Of the matters that run, when matters run,
Well, even if they don't run,
Well,
you don't know that before you brief.
yes, well, between myself and my colleague Bruce Shipalana, if it appears that the matter is not going to be particularly contentious and that it can be dealt with in-house and it's not going to create a scheduling conflict, then we will deal with it in-house and Mr. Shipalana will invariably do the appearances. So he does a lot of the appearances himself. It depends on the particular case and on the
Let me
calendar.
ask it differently. Of the number, whatever number out of the 50,
Yes.
40 or 30 where you do brief counsel, what percentage or number do you brief black counsel or women
I would have to
counsel?
say half. I can't be more precise than that, but I would say about half.
Okay. Have you ever briefed a black senior counsel?
No.
And if the half that you're talking about, is it those three people, Helen and Nogulunga?
Well, primarily in the last few years, it would be Miss Mokopo and Miss Adam, yes. Miss Ngomane was a while ago. When pressed for a name, I recalled her name, but primarily the last few years have been those other two.
And I'm sorry, CJ, can
They are becoming many now.
Just the last one. I'm sorry. You expressed some views about the marginalization, I think would paraphrase it, of attorneys in favor of advocates in some article that is here. Can you just tell us what that was about?
Yes, Mr. Mpofu, it wasn't an article. It was there was a panel discussion at the annual general meeting of the Black Lawyers Association, and the focus of the discussion was in regard to fusion of the profession. And Advocate Fazile Mamani spoke for the bar and for separation, and I spoke in favor of fusion and having a unified profession. And so my comments were made in that context. But I think it does raise a very important issue, and that issue really is the issue of access to justice. I think those of us in urban centres tend to think that everything happens at the High Court. My own view is that the issue of access is a far wider one. There are people in small towns and so on who also need access to justice, and a fused profession where one has legal practitioners put into the marketplace who have the same entry-level skills on all levels will enhance the service that can be given to members of the public and will enhance their own access to justice. So my position, just to wrap this up, is not that there's no place for advocates, but rather that there's a place for a unified profession where everybody who enters has the same skill set and the same opportunity to advance themselves. Those who want to do court appearances and focus on it and are proficient at it will naturally gravitate to it. But it doesn't mean that someone who chooses to practice in a small town away from a high court ought not to have those same skills, because having those skills means that the representation that they can give to their client will be enhanced and of greater value. So it's a question of ensuring that the greatest number of of practitioners have the best possible skill set at the start of their professions, so that whichever path they choose, they're all equally skilled and we don't have an imbalance of skills. And then following on from that, for the people of the country, that when they speak to an attorney in a small town, they're not speaking to someone who has absolutely no idea as to what happens in a high court, that he's actually will have a basic level of knowledge and experience to be able to pass that on. I think that was the context. I did see the quote, but it's a selective quote. It doesn't record the entire discussion and debate that took place that day.
Okay. Thank you, Chief Justice. Sorry for exceeding.
No, I understand, my brother. Thank you. You're excused, Mr. Miller. Thank you so much.
Thank you, Chief Justice, members of the Commission.
Thank you, sir.